This quite recent High Court case is usually studied as a human rights case or as a Section 109 constitutional case regarding inconsistency between state and Commonwealth laws. We're going to set those issues aside and focus on a few paragraphs from Justice Gummow's judgment on the Section 109 issue. Now, those of you who have studied constitutional law will know that Section 109 says, when a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. Justice Gummow stopped to ask the question, what do we actually mean by a law in that sense? He started by noting that the Constitution was written during a period of legal history when the positivist approach to jurisprudence was prevailing. He said, the Constitution was framed, at least so far as Section 109 is concerned, during the currency of doctrines which have been described as legal positivism and are associated with the writings of Jeremy Bentham and John Austin. However, Justice Gummow, following the approach of Justice Isaacs in the much earlier case of Clyde Engineering and Calburn, and also, without citing them, echoing the theories of Professor H.L.A. Hart, said that the written laws were in effect the commands of a sovereign authority. He said, the terms command, duty and sanction were used in this discourse each to denote an inseparable element of the notion of a law imposed by a sovereign authority. The result of this was that when considering whether two laws were inconsistent for the purposes of Section 109, it was necessary to ask more than just the question of whether the words written in each statute book were inconsistent. It was necessary to ask, what commands do those words give? What rights do they create and what obligations do they impose? And what sanctions or remedies are imposed if those rights or duties are breached? He quoted Justice Isaacs in Clyde Engineering and Calburn, who said, the law is not a piece of paper. It consists of the rule resolved upon by the Parliament as that which is to be observed positively and negatively by action or inaction according to the tenor of the rule adopted. Jeremy Bentham died in 1832. I bet he'd be chuffed to know that his jurisprudence was quoted in our High Court in 2011.